Good evening. On behalf of the UCLA School of Law, I would like to welcome everyone to the 2014 Allan C. Lebow Supreme Court Review, which is our annual Whither the Court program on the Supreme Court's most recent term and its implications for lawyers, academics, and citizens. Now, before I say anything else, I do want to acknowledge the organizers of tonight's event, Brad Sears and Randy Bunnell. Where's Randy? There he is. Who are both part of our Williams Institute on Sexual Orientation and Gender Identity Law and Public Policy, as well as Kathy Mayorkas, who is involved with our Epstein program in Public Interest Law and Policy. Events like tonight's really don't happen by themselves. They happen because Brad, Kathy, and Randy asked, entreated, nagged, thanked, reminded, organized, and cajoled. So to the three of you, our sincerest thanks. Now, beginning in 2003, this program evolved into a school-wide tradition for launching the academic year. For some of you, this has become an annual event. For others, it may be your first occasion to attend one of the numerous symposia, colloquia, workshops, and similar events that testify to the intellectual life of this community and to its remarkably wide range of interests. But whether you're a veteran or a newcomer, a student, member of the faculty or staff, a visitor, welcome. Tonight's event marks the opening of a rich series of compelling conversations about contemporary challenges in law and policy. It is a testament both to the unparalleled diversity found here and to the breadth of our research and curriculum. Our discussions tonight are the kind of inquiries that we will continue to engage in throughout the year, in our classrooms, with our extracurricular programming, and through our scholarship. What UCLA Law has to offer is not only the academic discussion of these questions, but innovative, considered, and research-based answers to them, answers that will shape the UCLA law community and our country. Now, before this begins, I would like to recognize one of our alumni, Cindy Lebow, who is here tonight, for appreciating all that the Whither the Court program has to offer through a special fund in honor of her husband. And she will have a little bit more to say about Allan later in the program, but I really want to take this opportunity to thank you, Cindy, for your generosity, which will allow us to continue this excellent tradition into its next decade. And I would also like to welcome and acknowledge our special guest tonight, Professor Laurence H. from Harvard Law School, who will provide tonight's closing keynote. Finally, I'm delighted to introduce this evening's moderator, Professor Adam Winkler. Adam is a leading scholar of American constitutional law. His research has been cited in landmark Supreme Court cases, including opinions on the Second Amendment and on corporate political speech rights. In 2011, he published Gunfight, The Battle Over the Right to Bear Arms in America, which the Los Angeles Times called, and I quote, intellectually satisfying, emotionally rewarding, an antidote to so much in the gun debate that is one-sided and dishonest. Adam is a frequent commentator on current legal issues, and his pieces have appeared in the New York Times, the Wall Street Journal, the Washington Post, and many more. So thank you, Adam, and welcome, everyone.
Thank you. Well, thank you all for coming out to Whither the Court and the 2014 Allan C. Lebow Annual Supreme Court Review. And a special thanks, of course, to my fellow panelists who you'll have the pleasure of hearing from today. At the end of this year's Supreme Court term, law professor and former acting Solicitor General of the United States, Neil Katyal, wrote an op-ed in the New York Times praising the justices for a remarkable number of unanimous or near unanimous opinions this term. Despite the goals of Chief Justice John Roberts, the court since he joined in 2005 has been starkly divided, with one 5-4 ruling after another. But this year, more than 65% of the cases were decided unanimously. The last year there were so many unanimous decisions was 1940. In many ways, this looks like the fulfillment of John Roberts' stated goals. During his confirmation hearings, he said he wanted the court to reach more narrow decisions that weren't split 5-4. This, he said, would help insulate the court from charges of partisanship. And yet, for most of his 9 years on the Supreme Court, that goal has been largely unrealized. This term, however, the justices joined together to strike down a law creating a buffer zone around abortion clinics, to require the police to obtain a search warrant before they search cell phones of people who are arrested, and to reject President Obama's appointments to the National Labor Relations Board. Has the Roberts Court turned a corner? Is unanimity the new normal in Washington? Or do these decisions mask deeper and more profound conflicts that are sure to rise up again in the future? Was this consensus, as Justice Scalia suggested in the abortion case, just, quote, specious unanimity? Was it phonymity? Phonanimity? I don't know which one it was, but we're sure to get some expert opinions tonight to help us sort this all out. Full biographies of each of the panelists can be found in your program tonight, but let me at least briefly introduce who will be speaking. Devon Carbado, 3 down from me, is the Honorable Harry Pregerson Professor of Law here at UCLA. He's a nationally recognized figure in the fields of critical race study, employment discrimination, criminal procedure, and, of course, constitutional law. Tonight, Professor Carbado will lead us into a discussion of the Supreme Court's decision in Riley against California. Sitting to Devon's left is Sue Dunlap. She is the President and Chief Executive Officer of Planned Parenthood Los Angeles, which provides health care services to tens of thousands of women in Los Angeles each year. Tonight, Ms. Dunlap will lead us in a discussion of McCullen against Coakley and its impact on abortion clinics. Sitting to Ms. Dunlap's left is Doug NeJaime. He is a professor of law at UC Irvine School of Law and currently a visiting professor here at UCLA. A former fellow at UCLA's Williams Institute, one of the hosts of tonight's event, which is also the leading sexual orientation law think tank in the country. He writes on sexual orientation law, family law, and law and social movements. Tonight, he will lead us in a discussion of Burwell versus Hobby Lobby. Eugene Volokh, at the very end of the table, is the Gary T. Schwartz Professor of Law at UCLA, widely recognized as a leading figure in the area of First Amendment law. Professor Volokh is also the founder of the popular blog, The Volokh Conspiracy, which I highly recommend to all of you who are interested in legal issues of the day. Tonight, Eugene will lead us in a discussion of Town of Greece versus Galloway, an important First Amendment case, and we'll also spend a few minutes responding to the Hobby Lobby and McCullen cases. Finally, as you already know, we're joined immediately to my right by Professor Laurence H. of Harvard Law School. A more complete introduction will be given of Professor Tribe a little bit later in the evening, but I'd like to remind you before we get there that after the conversation tonight, please join us in a reception outside where Professor Tribe will be signing books, hopefully, in the blood of Supreme Court justices.
I'll sign them if you buy them.
I strongly recommend the book, so you're going to want to buy it and get it signed. And I also encourage you to follow along on Twitter or to post your comments. We have our Twitter hashtag up behind me. It's a bunch of capital letters. I'm sure you can figure it out. I'm going to start us off in our discussion tonight because my role tonight is not just as a moderator, because I'm really not that moderate, as people who know me will tell you, but I want to talk about the McCutcheon against FEC case. So I'll start us off tonight with an overview and analysis of the McCutcheon against Federal Election Commission case, really one of the most important First Amendment cases of a term filled with important First Amendment cases. This case involved a constitutional challenge to provisions of federal campaign finance law that set caps on the total amount an individual could give to all candidates and political parties and political action committees in a given election cycle. In previous cases, most notably a 1976 case called Buckley against Volokh, the court upheld caps on how much an individual could give to a single candidate. Currently, the law stands at $2,600, the cap that you can give to one candidate. McCutcheon was a challenge to other provisions of the law that established a cap on the amount you could give to all candidates combined and political committees, which amounted to a little bit more than $120,000 over a 2-year cycle. Sean McCutcheon, an Alabama businessman, wanted to give more than that. He was fine following the $2,600 cap to one particular candidate, but wanted to be able to give that amount to more candidates than he could under the current caps. The current cap, aggregate cap, he could give that amount to about 9 candidates, and he wanted to be able to give it to more than 9 candidates. I think he had identified at least another 10 he wanted to give a substantial amount of money to. He argued that by capping the total amount he could give to all candidates combined, the aggregate cap violated his right of free speech and freedom of association under the First Amendment. The Supreme Court, by a vote of 5-4, agreed, striking down the aggregate caps. Obviously, this case was not one of those that earned the honor of even faux-nanimity. Or is it faux-nimity? I don't know. But Chief Justice Roberts wrote the controlling opinion for the court on behalf of Justices Kennedy, Scalia, and Alito. Justice Clarence Thomas agreed with the result, but wrote separately. Roberts explained that under the court's precedents, including Buckley, the ability to contribute to a candidate or to candidates for elective office is a fundamental right stemming from the First Amendment. Quote, he said, "There is no right more basic in our democracy than the right to participate in electing our political leaders, including by making financial contributions to their campaigns." Now, just because you have a right to contribute to candidates doesn't mean the government can never restrict that right. No rights are absolute, but the government can only burden your First Amendment rights when it has very strong reasons. The FEC, the Federal Election Commission, argued that in this case they did have very strong reasons, and Congress had strong reasons to justify the aggregate caps. The FEC argued that the aggregate caps help prevent the appearance of corruption. Such an appearance of corruption might arise, the FEC argued, if wealthy individuals could give money, hundreds of thousands of dollars, across an array of candidates. The aggregate cap also served to shore up the basic contribution limits that the court had previously upheld in cases like Buckley, according to the FEC. If someone could give unlimited amounts to party committees, or at least to give to an unlimited number of party committees, some of that money could end up flowing back to the individual candidates to which the donor has already maxed out. He's already given $2,600 to candidate X, and there was some concern that money that went to a political committee could end up being funneled back to that candidate, in which case the individual would have effectively given more than $2,600 to that particular candidate. So the law, according to the FEC, served to combat circumvention of the basic $2,600 caps. The court disagreed with the FEC's argument. In perhaps the most important part of the McCutcheon ruling, Chief Justice John Roberts wrote that there was only one kind of corruption that Congress can try to combat by limiting campaign contributions. This kind of corruption was what he called quid pro quo corruption. Now, quid pro quo corruption, I challenge you to say that 10 times fast. I can barely get through it once, slowly, occurs when an official trades some official act for money. Maybe implicitly, but there's nonetheless some kind of direct trade-off, action for funds. Now, according to the Chief Justice, making contributions in the hope of gaining influence and access is not a form of corruption, and that's what McCutcheon was trying to do. Indeed, the Chief Justice argued, influence and access are other words for democracy. We want elected officials, he argued, to be responsive to their constituents. There was no claim here that the aggregate caps prevented quid pro quo corruption. If it isn't corrupt for Sean McCutcheon to give $2,600 to 9 candidates, which was allowed, why would it be corrupt for him to give the same amount to a 10th candidate, or an 11th candidate, or even a 12th candidate? The Chief recognized that the FEC may have appropriate cause to be concerned about circumvention of the basic $2,600 caps. However, he suggested there are other ways to do it without limiting Sean McCutcheon's First Amendment rights. For instance, Congress could pass laws that restrict the transfer of funds between candidates and political committees. That would serve the same end without restricting individual donors' First Amendment rights. Justice Clarence Thomas agreed with the result that the Chief Justice reached, but wrote separately to argue that the court should strike down all contribution limits, including the basic $2,600 caps, that the experiment with campaign finance law should come to an end, and that campaign finance law of the sort that we've seen over the last 40 years amounts to a violation of First Amendment rights. 4 justices in the case dissented. Justice Breyer, writing for Justices Ginsburg, Sotomayor, and Kagan, wrote that the aggregate caps should be upheld, and he argued that the majority had defined corruption too narrowly. The influence and access obtained with monetary contributions were not, according to Justice Breyer, a central feature of democracy, as the Chief Justice had suggested. They were, instead, a bug. Breyer wrote that if people believe that elected officials only pay attention to big money donors, they may lose faith in the political system. The majority, Breyer wrote, quote, eviscerates our nation's campaign finance laws, leaving a remnant incapable of dealing with the grave problems of democratic legitimacy they were designed to resolve. The McCutcheon decision has been likened to other famous campaign finance decisions of the Roberts Court, Citizens United among them. That case invalidated restrictions on corporate and union financing of independent election ads. That is, ads run without being coordinated with the particular candidate. Now, both McCutcheon and Citizens United are part of a long-term trend in the Roberts Court. Although this court has been known as a First Amendment-friendly court, vigorously protecting speech rights, the plurality of speech restrictions struck down by this court deal with campaign finance law. In fact, since Roberts joined the court in 2005, the court has struck down or narrowly construed every single campaign finance law to come before it. So whether or not the Supreme Court is First Amendment friendly, it's certainly not friendly to campaign finance law. With the very narrow definition of corruption espoused by the McCutcheon majority, we're also likely to see additional campaign finance cases or finance laws invalidated in years to come. Some political scientists, however, cheered the decision. One effect of the campaign finance laws of the past 40 years has been to push money to outside groups that operate independently of candidates. Because there have been caps on contributions, the amount you give directly to a candidate, and restrictions on money you can give to political parties, but no limits on the amount you can give to independent groups that aren't coordinated with candidates, lots of money is flowing to outside groups rather than going to the candidates and to the political parties. For example, in the 2014 presidential election, Sheldon Adelson quite notoriously gave $90 million to efforts to try to elect Mitt Romney. He didn't give that money to Romney, however. He could only give $2,600 to Mitt Romney. He couldn't give it to the GOP or to affiliated political committees because of the aggregate caps. Instead, he gave it to outside groups, 527s, super PACs, other kinds of organizations, things like the Chamber of Commerce, that would use that money still to elect Mitt Romney, but not in coordination with Mitt Romney. Many political scientists believe that that money, if it's going to flow into American politics, is better served by flowing into candidates and political parties. Money that goes to political parties and candidates is disclosed so that voters can see the money and see where it goes. If a voter thinks that that money is corrupting of a candidate, he doesn't have to support that candidate and can vote against him. Yet, when money flows to outside groups, there is no disclosure and there is no accountability. And as a result, many political scientists have argued that we should try to encourage rules that are going to funnel money back to the political candidates and to the accountable political parties rather than, as Sheldon Adelson's money went, to outside groups. Well, one thing is for sure. We haven't heard the last of campaign finance law in the Roberts Court. I'd like to turn it over now to Devon Carbado, who's going to talk about the Riley case.
Good evening, everyone. Is this on? Can you all hear me? Great. So the subject of my presentation is Riley versus California, a case that's at the intersection of Fourth Amendment law and technology. Here, more specifically, is how I want to engage that case. I'll start at the very beginning, because it's a very good place to start, with a discussion of the text of the Fourth Amendment. Then I'll introduce the general analytical structure the Supreme Court employs to make sense of that amendment. Third, I'll situate the Riley opinion in the context of that analytical structure so that you have a clear understanding of what doctrinally was at stake. And then I'll say a few things about the implications of the case. All of this, presumably in 10 minutes, which is to say, may the force be with me. All right, so the text of the Fourth Amendment protects us from unreasonable searches and seizures and provides, among other things, that warrants require probable cause and particularity. Three ideas flow from that, two inexorably, and one by way of judicial interpretation. Idea one, governmental conduct that does not constitute a search or a seizure is governmental conduct that resides beyond the regulatory reach of the Fourth Amendment, which is to say, if it's not a search or a seizure, the Fourth Amendment has nothing to say about it. Idea two, even if it's a search or seizure, that doesn't mean it's constitutionally problematic. The Fourth Amendment prohibits unreasonable searches and seizures, not searches and seizures per se. The third idea, warrantless searches are presumptively unreasonable, except for a few, quote, specifically established and delineated exceptions. Now, I have to say that specifically established and well delineated are not terms that readily come to mind when one thinks about Fourth Amendment jurisprudence, but at any rate, those are the ideas that underwrite this body of law. The question becomes, where does Riley fit in? So Riley involved a police officer who went into the cell phone of a suspect, looking at pictures, looking at text, looking at videos. There was no dispute in the context of the case as to whether or not that governmental activity constitutes a search. It does. There was no dispute in the context of the case about whether that search was warrantless. It was. The question became whether the search was unreasonable, and more specifically still, whether the search constituted one of the quote-unquote well-delineated, specifically established exceptions to the idea that warrantless searches are presumptively unreasonable. The government argued that one such exception applied, the search incident to arrest doctrine. And roughly, there are three factual contexts in which that particular doctrine can kick in. So the search of the place incident to the arrest of the person, the search of the car incident to the arrest of the person, or the search of the person incident to the arrest of the person. This case implicated the third category, that is to say the cell phone was found on the body of the person incidental to that search. As a formal doctrinal matter, then, the government was entirely right to invoke the search incident to arrest doctrine, and the government was interested in trading on a particular feature of this doctrine. So the search incident to arrest doesn't require any independent justification. To put it the way the Supreme Court has, the authority to arrest carries with it the authority to search. So if the arrest itself is legitimate, the search automatically follows from that. Two policy rationales underwrite this particular doctrinal regime. One, a concern about officer safety, and the other, a concern about destruction of evidence. In effect, the Supreme Court has said that these two concerns function as what you might call categorical exigencies, meaning we're going to assume that these concerns exist every time there is a search incident to arrest, so that we're not going to require the government to demonstrate their existence in the context of any particular case. The government, in the context of this case, pushed that argument really hard. We had a legitimate arrest, no dispute about that. We had a search, no dispute about that. Ergo, the search incident to arrest doctrine applies. Everyone followed the logic of that argument. The court pushed back, and the court pushed back along three important dimensions. Pushback one, cell phone searches do not present a risk of safety to officer. Cell phone searches do not present a concern about destruction of evidence. In other words, the two policy rationales that underwrite the search incident to arrest doctrine simply do not obtain with respect to cell phone searches. Pushback two, cell phone searches are really, one more time, really different. They are different qualitatively and quantitatively. Think, for example, about their storage capacity, the court wants us to know. And think about the vastness of the material that is stored thereon. Emails, voicemails, call logs, an app for that, which is to say, an app for just about everything, our browsing history, etc., and so forth. Moreover, the court went on to say that it's something of a misnomer to think of a cell phone as a container. Indeed, even the notion of a digital container doesn't quite capture it, to the extent that the information that cell phones have access to are not necessarily stored on the cell phone itself. All of this is to say, from the court's perspective, there's a kind of quote-unquote pervasiveness to cell phones. All of us have cell phones, or most of us at any rate, and cell phones are effectively transcripts of our lives and intimate details of our lives. For the court, then, the foregoing suggests that the search incident to arrest doctrine simply should not apply. The third pushback was less of a pushback and more of a mediation, if you like, on the role of technology in everyday life and what that might mean for the kinds of police investigatory practices that we permit. You might call this the Justice Brandeis moment in the opinion, in the sense that Chief Justice Warren invokes writs of assistance, invokes general warrants, and invokes the very American Revolution. You add the requisite exclamation points to make the point that we should be thinking about the relationship between the kinds of technologies that government have access to on the one hand and democratic order on the other. You read that part of the opinion, and you should read it. It's at the end of the opinion, and you think the American anthem, you hear the American anthem rather, you see the American flag, and you may even think Superman, up and away. The point is that he wants us to really think hard about how technology can erode the kind of democracy we've come to accept. So, the black letter takeaway. What does this case ultimately hold? Well, A, the search incident to arrest doctrine does not apply to cell phones. That means that to the extent that the government wants to search cell phones, the government must apply for a warrant, except if the government can show exigent circumstances, which is to say the government is still free to make a situational argument about exigency. It just can't trade on the idea that exigencies are always there. So 3 short observations about this case, and then I will shut up. First, one can query whether the court's line of argument that cell phones are really different goes too far. Significantly, the per se dimensions of the search incident to arrest rule are not nearly as per se-ish, if that's a word, as you might think at first blush. So it's true that the government is permitted to search me incidental to arresting me, but the government couldn't perform a strip search. That would be problematic. With respect to the body, there are different kinds of searches that have different kinds of intrusiveness that require different kinds of justification. So frisking me, you might require reasonable suspicion, which is a little bit more than a hunch. An ordinary search would require probable cause, a little bit more than reasonable suspicion. A body search might require a warrant, a little bit more than ordinary probable cause. And some kinds of searches are not even permitted with a warrant. So there's a level of intrusiveness that seems to matter. Even with respect to a car search, we take that into account. So you might be surprised to learn, for example, that you can frisk a car, which is different from fully searching a car. One could take a similar approach to cell phone searches, which is to say, differentiate between moments in which an officer looks at the call log, which is what happened in the companion case, from moments in which an officer looks at videos or pictures or text, which is what happened in this case. I'm not suggesting that I'm in favor of that approach. What I am suggesting is I don't think that the court took that argument as seriously as it might. Second, if orange is the new black for purposes of Netflix, one might query whether cell phones are the new home cell phones are the new home for purposes of the Fourth Amendment. That is to say, whether cell phones will replace the home as the domain for the quintessential expectation of privacy. I think that's a question that this case invites us to take up. Third and finally, all of the discussions about the technological aspects of this case. So what does this case mean, for example, vis-a-vis NSA surveillance and data collection practices? What does this case mean for governmental access to data stored by third parties, like telephone companies? These questions strike me as enormously important, but they elide another feature of the case that relates to discretionary police power that this case also puts into sharp relief. Significantly, the search incident to arrest doctrine applies for any, underscore, any custodial arrest. So for failing to wear your seatbelt or any traffic infraction kicks this document in. Because all of us commit traffic infractions all of the time, and I mean that, to get in a car is to commit a traffic infraction. If you didn't know, you know now. That means police officers can decide which one of us to stop, which one of us to arrest, and which one of us to subject to a custodial search. All of this, of course, implicates concerns about racial profiling. So an officer might decide to stop Johnny, not because Johnny committed a traffic infraction, but because of Johnny's race. Perfectly legal under Fourth Amendment law. Or an officer might decide to stop Johnny, not because Johnny committed a traffic infraction, but to investigate Johnny for some crime for which the officer doesn't have probable cause. Again, perfectly legitimate under Fourth Amendment law. Historically, the court has not been terribly concerned about racial profiling or pretextual stop. This is a moment in which the court is saying, not in my backyard, or more precisely, not on my bloody cell phone, right? So one can read this case as an instance in which it wasn't easy for the court to externalize the cost of permitting a particular police investigation practice. In conclusion, clearly the story about the Fourth Amendment and technology remains to be fully articulated or litigated or whatever. But Riley versus California, it seems to me, is an important chapter, one that pushes the court further in the direction of the digital age. Thank you very much.
And next up, we'll have Sue Dunlap.
So there were a couple of you who came in were sort of being shy. Were there any more of you who want to come and sit down, or did everybody get in? All right, great. So how many of you have spent any time in law school? Would you raise your hand? All right. Not many of the people in the panel, including myself. And then, so that was most of the room, but not all of the room. How many of the people in the room have women in your life, whether those be grandmothers, mothers, daughters, wives, friends that you love? All right. So my talk tonight is going to be speaking to the women and the people in the room who have women in their lives that they love. I'm the CEO of Planned Parenthood Los Angeles. We're the second largest Planned Parenthood in the country. We provide life-saving cancer screenings, STD treatments, STD tests, birth control, abortion, vasectomies, and a wide range of reproductive health care. We see about 1,000 people a day in our 19 health centers, just in Los Angeles, and we take about 2,500 calls a day. That's my way of saying, we see a lot of people. I'm not an attorney, I'm not a doctor. As a CEO, it's my job each and every day to keep all of our patients and all the people who are calling us safe and to protect their privacy. It's my job to keep our staff safe, and my job to keep the thousands of volunteers who work with us each year safe. McCullen versus Coakley, arguably, and I think a couple of you will help clarify this a little later if I don't get the details quite right, makes my job harder. What it did basically is in Massachusetts, it took away a 35-foot buffer zone around health centers that provide abortions. 35-foot buffer zone. Does everybody pretty much know what that is? Yeah? Does anybody know loosely that the Supreme Court and the justices have their own buffer zones? Do you guys know that? Do you know? So I'm talking about one that was 35 feet. Who knows how big the buffer zone is around the Supreme Court? Is it 50 feet? Is it 100 feet? It's a bigger number, right? 150 feet? 250 feet. So the Supreme Court justices, when they're going into work, have a 250 feet buffer zone that protects them. Am I getting this right more or less, Adam? Yeah, okay. That protects them from the speech or the conversations that folks who come to the court and either agree or disagree or have comments or ideas about their decisions. But when women or employees go to Planned Parenthood in Massachusetts, those folks who are going there for a protected service, whether it be birth control, whether it be cancer screening, whether it be abortion, whether it be a vasectomy, don't have that same protection. I just want to make that real clear. Does that make sense to everybody? I heard some no's. To me, it doesn't really make sense, but I hope my explanation made some sense. So one part of this decision found that it was very important, and again, you guys correct this if I don't get this quite right, that it was very important to protect the First Amendment right of sidewalk counselors. How many of you, separate from those of you who are women, so that's, probably about half of you, separate from those of you who are women, and women who've gone to a reproductive health care clinic, have ever gone for health care and had somebody on the sidewalk with no credentials whatsoever offer you counseling about whatever it was you were going to get care for that day? You guys have? All right. I'd love to hear more about the care that you get and where you go another time. But for the most part, you all don't go to the doctor and expect someone to stop you on the sidewalk and say, hey, I know you've talked to doctors, I know you've talked to your family, I know you've probably looked on Google, but I want you to think one more time about what you're doing here today. You don't really expect that to happen, and if it did happen, I think you'd probably expect that there was some credential that went along with that. But nevertheless, and of course, right, I'm not posturing in any way that I'm a neutral person in this conversation, but nevertheless, the Supreme Court decided that these folks have the First Amendment right to provide, and this is language, these are quotes, close, compassionate, personal guidance to women and men coming to a health center that provides abortions. Okay. Does that make sense to y'all? Yeah, no, yeah, right, okay. So, Dr. Carbado, I very intentionally...
Devon will do.
Devon. Sorry, I'm going back to the mic. I circled a story on there. So in a second, I'm going to ask you to read that story. And then I'm going to tell another one. At Planned Parenthood Los Angeles and at Planned Parenthoods all across the country, we get stories and letters from people who've come to us. 1 in 5 women across the country have come to a Planned Parenthood. 98 to 99% of women use birth control. We get thank you letters from a whole lot of you. I don't want to make them, it's us. But I want you to hear this one story, and then I'm going to tell you another story. And I'm going to ask you to think about, as you hear these stories, did these women, either one of them, need close, compassionate, personal conversations or guidance? I might call it confrontations, because this guidance often comes with a large sign, you've all seen them, of sort of very large, very bloody fetuses, and it often comes with very unscientific information. But did these women need, I would say, one more barrier to care? Could you go ahead and read that first story?
I was 19 years old when I got pregnant and had a medication abortion at 6 weeks. At that time, my boyfriend, who is now my husband, and I were using condoms. I remember feeling terrified, alone, and hardly able to come to terms with the inevitable fact of my pregnancy, motherhood, and a baby.
There's another one that's circled that's down at the bottom. Could you read that? Could you read that one too? Could somebody else read that one? I'm sorry, I meant a different one, but thank you for that one. That's a good one too.
I was 19, living on my own with hardly any money. I had a couple of close calls that worried me that I might become pregnant and have to decide between having a baby or having an abortion. I had just started college, and that was the last decision I wanted to make. I went to Planned Parenthood and talked to a clinician about my situation. She suggested an IUD, a type of birth control that's effective for 5 years. I didn't have insurance and couldn't afford it at the regular price, but because of my low income, Planned Parenthood did it for free. Thanks to Planned Parenthood, I can finish college without the chance of an unplanned pregnancy. I'm among the top of my class, and I'll be graduating next year with a degree in aerospace engineering. I owe a thank you to Planned Parenthood.
So we may all have different opinions about that, but the question again I want you to think about is, did she need one more barrier to care? Now I'm going to tell you a story. Our medical director, this is a story that happened a few years ago, and I'm going to tell it in a way that protects the privacy of the people who are in it. A few years ago, our medical director of about 20 years, and I'm mentioning that intentionally, because if you think about what it was to be a medical director providing abortion care 10, 15 years ago, you'll remember that that was at a time when people terrorized and sometimes shot doctors. So she went to one of our health centers one day and saw in the waiting room someone she had seen who was identified as a sidewalk counselor every Friday and Saturday at a different one of our health centers. And this woman was inside the waiting room. Our medical director was terrified. She called our security department, and then right after that, she called me. So what turned out to have happened is this woman, this sidewalk counselor, was at this other clinic, besides the one she was always at, with her daughter. Our medical director was the practicing provider that day and was there providing abortions. So when the daughter came back, and after she had had her procedure, and when the mother, the sidewalk counselor, came to join her in the recovery room, our medical director couldn't help herself but to come out and sort of say, I know you. I've seen you for years, every Friday and Saturday. I don't understand. And the woman said, my daughter's not like those people. She needed this. And I offer that with no judgment. It's our job at Planned Parenthood to take care of people, no matter their situation. But I want you to think again about that question. Did either of those women, or maybe there's 3 women in these stories, maybe there's hundreds of women in these 2 stories, did any of them need one more barrier between the decision that they made and their families, between them and their doctors? And I'd suggest to you that the importance of the buffer zone is that it lets women safely get the care that they need at a time when they're incredibly vulnerable. And the next time you go to the doctor and you're a little bit nervous, you're a little bit scared, I want you to think about what it would be to have someone there telling you, questioning your decision, and put yourself in her shoes. Thank you.
So I already got to talk about cost-free contraception, which is a great lead into my discussion of Hobby Lobby. And I'm especially glad that Sue is here, because otherwise this would feel like a recreation of the congressional hearing in which a bunch of men sat at a long table and talked about women's reproductive health. So I want to thank Cindy for sponsoring this really great event, and thank also Brad and Kathy and Randy for coordinating all this, and Adam for moderating us. So I am talking about Hobby Lobby, which is the Supreme Court decision that allowed closely held for-profit corporations to assert claims under the Religious Freedom Restoration Act, which is RFRA. RFRA prohibits the government from substantially burdening a person's exercise of religion unless the government demonstrates that application of the law furthers a compelling governmental interest, and that the law is the least restrictive means of furthering that interest. So RFRA purported to fill the void left when the Supreme Court interpreted the free exercise clause to be relatively toothless. So the employer claimants in Hobby Lobby sought exemptions from provisions of the Affordable Care Act that required them to provide their employees health insurance benefits covering contraception. And the coverage of certain contraceptives, they claimed, would make them complicit in abortion. A lot of attention has focused on the kind of claimant in this case, closely held corporations, but I want to spend my time talking about the kind of claim, a claim of complicity. And I want to draw on work I'm doing with Reva Siegel on this topic, focusing on an important limitation that the court seems to place on accommodation, a limitation that will be crucial as we deal with similar kinds of claims in the context of abortion, contraception, same-sex marriage, and LGBT equality. In Hobby Lobby, the court required a religious exemption on the understanding that accommodation is possible without harm to third parties, in other words, the women seeking access to contraception. The court began its opinion by emphasizing that the effect of accommodation on the women employed by Hobby Lobby and the other companies would be, quote, precisely zero. This is consistent with much of adjudicated religious liberties law. In the classic free exercise cases to which Congress looked when it passed RFRA, the sought-after accommodations posed only limited and relatively diffuse costs. We see similar resistance to third-party harm in other areas of religious liberties law, including Establishment Clause jurisprudence and Title VII. So I want to tentatively read Hobby Lobby within this tradition and then suggest the danger that it could jump the tracks given the distinctive kind of claim, a claim of complicity, at issue in the case. Although the majority opinion merely stipulated that the government had a compelling interest in ensuring women's access to contraception, 5 members of the court, Justice Kennedy, who concurred, along with 4 dissenting justices, explicitly validated the government's compelling interest. Justice Kennedy was clearly concerned with the impact of accommodation on the statute's beneficiaries. At oral argument, he questioned how accommodation would affect, quote, the rights of the employees who may not agree with these religious beliefs of the employer. And in his Hobby Lobby concurrence, he noted that the accommodation of religious liberty may not, quote, unduly restrict other persons, such as employees, in protecting their own interests. These concerns about the harm accommodation might inflict on the statute's beneficiaries shape the terms on which the court recognized the plaintiff's RFRA claim. Justice Alito's opinion for the court turned to the narrow tailoring inquiry, what RFRA refers to as the least restrictive means, to resolve the case. Because the majority concluded that the government could vindicate its interest in women's access to contraception without burdening the objectors, it granted the sought-after accommodation. Days after its Hobby Lobby decision, the court in Wheaton College sanctioned another RFRA claim in the context of the contraception mandate. Wheaton College, a religiously affiliated institution, claimed that the self-certification form, which is the accommodation mechanism provided by the government to religiously affiliated nonprofits, quote, will make it complicit in the provision of contraceptives by triggering the obligation for someone else to provide the services to which it objects. Again, the court granted the exemption on the assumption that third parties would not bear the impact. The court explained, nothing in this interim order affects the ability of the applicant's employees and students to obtain without cost the full range of FDA-approved contraceptives. Wheaton College, like Hobby Lobby, appears to tie accommodation to the fact that the government has other ways of providing for the statute's beneficiaries, such that no third-party harm would result from the accommodation. But no passage in either the majority opinion in Hobby Lobby or in Justice Kennedy's concurrence or any language in Wheaton College expressly commits the court to this reading of RFRA in future cases. And the court's decision in Hobby Lobby is now being cited to support accommodation of claims not merely in litigation involving insurance for contraception and not merely in litigation under the federal RFRA, but also in a wide range of legal, factual, and institutional settings. In the LGBT context alone, Hobby Lobby already has been used to bolster claims to exemptions from state anti-discrimination law requiring businesses to serve same-sex couples, and the federal executive order banning sexual orientation and gender identity employment discrimination by federal contractors. Therefore, it's important to explore the concerns about third-party harm that already structure Hobby Lobby, and to consider how it may not be possible in many contexts to design an accommodation that actually blunts the impact on third parties. Here's where it's crucial that we pay attention to the kind of religious liberty claim the court sanctioned in Hobby Lobby. The employers argued that providing insurance coverage would make them complicit with employees who might use the insurance to purchase forms of contraception the employers viewed as sinful. Claims of this kind, a religious objection to being made and complicit in the sinful conduct of others, are often raised in response to contested sexual norms. Today, complicity-based claims are expressed about persons who act outside traditional family roles, engage in contraception, abortion, or assisted reproduction, cohabit or have children outside of marriage, or enter a relationship with or marry a person of the same sex. Consider, for instance, claims arising in the same-sex marriage context. I'm sure you all know, a growing number of bakery owners have begun to voice religious objections to providing cakes for same-sex weddings, and some of these are subject to litigation right now. Baking the cake, it is claimed, makes the baker complicit in a same-sex relationship to which he objects. Complicity-based conscience claims express religious beliefs about the conduct of others in the community. The claim concerns a third party's conduct, for example, her use of contraception or his same-sex marriage, and it also concerns the claimant's relationship to that third party. Because these claims are explicitly oriented toward third parties, they present special concerns about third-party harm that aren't present in cases concerning Saturday Sabbath observance or ritual peyote use, the classic free exercise cases Congress looked to when it enacted RFRA. Complicity-based claims are now being asserted by growing numbers of Americans about some of the most contentious culture war issues of our day. The religious claimants seek to restrict enforcement of laws that are designed to protect others whose beliefs and actions the claimants condemn. Accommodating these religious liberties claims has social meaning and practical consequences for the persons the claimants say are sinning. So the claimant can obstruct access to goods and services. For instance, in the healthcare context, some state laws allow healthcare providers and institutions who want to avoid complicity to refuse to provide abortion or contraceptive services, even in an emergency situation. And other laws allow these same providers and institutions to refuse to refer or counsel or provide information on these issues, meaning that the third party may never receive information that would even lead her to pursue alternative care. Here, complicity-based objections are accommodated without an offset to prevent harm to third parties. But these harms go beyond access. The refusal itself expresses the claimant's view of sinfulness in a way that may stigmatize the third party. For instance, in the same-sex marriage context, a bakery customer refused service recalled, quote, walking away feeling hurt and disgusted. Another reported that she never felt so low in her life as when the owner terminated the cake testing upon finding out that the woman was a lesbian. Most recently, a lesbian couple turned away by a wedding venue near Albany, New York, reported that the state's Human Rights Division feeling shell-shocked and horrible. While one of the women had been feeling a lot more comfortable with herself since coming out, she experienced the refusal as a kind of blow to her coming out process. Because the refusal is based on a well-understood belief, one that views same-sex relationships or same-sex marriage as sinful, the customers understand the social meaning that the refusal conveys. And because this type of refusal is now iterated across domains with increasing frequency and concerns norms that continue to be contested at a society-wide level, its power is amplified. Hobby Lobby devoted no attention to the dignitary dimensions for those on the other end of the religious claim. The court was concerned specifically with coverage for contraception without cost sharing. It focused on accommodation's material impacts, namely money and access. What was missing from view in the decision was meaning. The case had not been litigated with dignitary harms fully in view, and while Justice Kennedy's concurring opinion acknowledged the dignity of the religious objectors, the court failed to recognize the dignity of the women at the other end of the objection. Even assuming the accommodation can be granted without material harms on third parties, it's not clear that such accommodation can offset the dignitary impact. Attending to those harms may be critical to distinguishing complicity-based conscience claims from other claims that seek religious exemptions. The challenge under RFRA, post-Hobby Lobby, is to take full account of the effects of accommodation of complicity-based claims, the effects they have on third parties, but within a doctrinal framework that actually doesn't make this consideration explicit. So third-party harm should be a feature of at least the analysis of the governmental interest and the narrow tailoring. But in many other contexts, complicity-based claims will be dealt with under state law or in legislatures. And in these settings, third-party harm could be directly addressed, and it should explicitly figure into the accommodation calculus with either a refusal to accommodate or accommodation designed to explicitly have an offset. Thank you.
Thank you. Thank you very much for having me here. The main case I'll be talking about today is Town of Greece v. Galloway, and this is yet another case that deals with the Establishment Clause. Now, the Establishment Clause prohibits Congress from passing a law, making a law, respecting an establishment of a religion. Over time, this has been applied not just to Congress, but to state legislatures and local government entities. There's some controversy in the court. Justice Thomas actually wrote a separate opinion arguing against that, as he had done several times before. But generally speaking, this is broadly accepted by 8 of the 9 justices. It has also been applied not just to legislative action, but also to executive action. But what is left open is what is establishment of religion. The question in Town of Greece immediately was what kinds of prayers conducted before legislative meetings, before city council meetings, are constitutional and which are not. And the question for each is, well, is having this kind of prayer an establishment of religion? Now, we know a little bit about what establishment of religion means because we knew at the time of the framing there was an established church that all Americans, who were actually Englishmen shortly before then, knew, which is the Established Church of England, a church where the king is the head of the church, where the Lord's spiritual sit alongside the Lord's temporal in Parliament, where there are limitations on offices in the state that are only open to members of the Church of England, all sorts of things like that. That was an established church. Pretty clear they wanted to forbid that. There were a few other things pretty clear they wanted to forbid. There had been requirements that people go to church on Sundays. That was a hallmark of an establishment. But beyond that, what's an establishment of religion is, at the very A, hotly contested, and B, not self-defining. That's the problem. We don't really have, it's not like an establishment is a term to us that has a standard, well-established meaning that we can understand, kind of like right to trial by jury. We understand a little bit of what a jury is, even though we may dispute exactly what the scope of that right might be. So that's what was at the heart of the debate in Town of Greece v. Galloway, and has been in some measure the heart of debates in Establishment Clause cases over the last 30 years. One common argument has been, and it was promoted by Justice O'Connor especially, and still is formally seems to be the majority view on the court, although it's not clear, that is to say, majority view of the precedents, although it's not clear that it's the majority view on the court today, is that endorsement of religion, government endorsement of religion, is unconstitutional. And if you take that seriously, then in that case, or if you take that as the Establishment Clause rule, then a prayer in front of a city council meeting is unconstitutional because at the very least it establishes religion, endorses religion in the sense of endorsing religiosity as the right thing and endorsing the existence of God. If you have prayers, you're presumably saying, well, there's somebody worth praying to. So if that were so, then legislative prayers would be unconstitutional. That view got 0 votes on the court. Got 0 votes from the conservatives, it got 0 votes from the liberals. Justice Kagan, writing for the 4 liberal members of the court, specifically said that her view is that legislative prayers, if properly done, are constitutional. This was not always unanimous on the court. In the Marsh v. Chambers case in 1983, it was only 6-3 majority in favor of that. Now it's 9-0. So the endorsement test, to the extent it still survives, clearly is modified by something. And that something, at least in considerable measure, is tradition. One of the problems with the endorsement test has long been that in American history, things that endorse religion are commonplace. Let's take the Declaration of Independence. Many people think of the talk of nature's God and endowed by their creator when they think about this declaration in religion. I want to go away from the opening paragraphs and go to the closing, where we, the representative of the United States of America, appeal to the supreme judge of the world for the rectitude of our intentions. And we pledge our lives, fortunes, and sacred honor. How? With a firm reliance on the protection of divine providence. This isn't just a deist watchmaker God. This is God the judge. This is God the protector. Obviously, the declaration is not a prayer in that it's something written, not oral, but it certainly sounds not that different from what legislative prayer has at times been. And in fact, there has been a long-standing tradition since the framing of allowing legislative prayer, literally since the very first Congress at the federal level and throughout the country at state and local levels. So all the justices agree that this is permissible. What's the difference? Well, the difference is the majority takes the general view, and I'm going to highlight a little bit of the difference between some of the justices on the majority on this, but it takes the general view that it is sufficient if the government doesn't deliberately discriminate in choosing which, based on religion, in choosing which chaplains to allow, at least in a context where they invite a bunch of chaplains. If they hire one chaplain, they obviously have to choose one and not others. But if they invite, as the town of Greece did, a bunch of chaplains, a different one each month, has to not discriminate based on religion. And on top of that, the prayer is at least viewed as an aggregate, not necessarily each one in particular, cannot denigrate non-believers or minorities, threaten damnation, or preach conversion. that if you set that aside as a general matter, prayer that is used to lend gravity to the occasion is constitutionally permissible. Even when, as in Town of Greece, a town, by the way, about the size of Santa Monica, all the prayers happen to have been given by Christian ministers. And I do say happen to have been because it does appear that there was no deliberate design to limit it to Christians. The city was overwhelmingly Christian, and while there were some religious minorities, the method that they chose for selecting chaplains, which was going through the telephone book and just choosing more or less at random, ended up not including them in part because the synagogue that many people, the Jews of Town of Greece went to, was outside of the town boundary, and apparently it was not a deliberate decision, and the court said that's fine. The dissent, again, agreed as to the core permissibility of legislative prayer, but what it disagreed as to is that its view was that when you have a prayer which, as in a town council, can be seen as including the public, being said to the public who are there to, among other things, have the business, their zoning matters resolved or their input considered in the legislative process, that prayer has to be one of two things. Either it needs to be non-sectarian so that nobody feels that they are being excluded by specific religious reference, at least nobody religious. The prayer would still be maybe not sectarian, but theological in the sense it would acknowledge a God. Or it would have to be done in a way where people are selected, the chaplains are selected with an eye towards greater religious inclusion, even if that means deliberately trying to find non-Christian ministers, for example. So if one of those two things was satisfied, then the dissent would have said that this would be permissible, but they said in Town of Greece this was not adequate. So actually, ultimately, this was one of those cases where there was 5-4 decision that actually masked a considerable amount of unanimity as to the big picture thing, although a very sharp division as to the permissibility of this particular practice. So that's Town of Greece. I want to turn briefly to McCullen versus Coakley and ask the question. This was a case where there was unanimity. There was a sharp divide in a doctrinal issue of content discrimination versus content neutrality. But on the bottom line of the unconstitutionality of the 35-foot buffer zone, there was total unanimity. So what I might ask is, if Justices Ginsburg or Breyer or Sotomayor or Kagan were here to listen to the earlier presentation, all justices who seem to be quite firm supporters of abortion rights, what would they say? Why would they vote for a decision that has all of these supposedly dire consequences? And I think, and I'm going to try to work with some of the things that the previous speaker pointed to, I think they would say, yes, free speech may make the job of Planned Parenthood harder. Free speech makes lots of people's jobs harder. That Planned Parenthood in this respect is like any place that is being picketed. Lots of businesses have experience with being picketed, either by labor unions or by public issue groups, could be animal rights protesters and so on and so forth. Free speech makes their jobs harder. Free speech is protected. Free speech includes the right to give counseling, even when we think, and even when the listeners may think it's not really necessary. It's true that the speakers lack credentials. The First Amendment protects the right to speak without credentials. Did these women need guidance? I personally don't think so. That's not the First Amendment test. It's not the test as to whether people who go to a store that's being picketed need guidance on labor relation matters. The picketers are still free to speak about that. There's a First Amendment right to convey even unscientific information. False it may be, unsound it may be, constitutionally protected. And yes, there's even a First Amendment right to question people's decisions. So I think that's probably what the justices would have said, and not just the conservative justices, but the liberal pro-abortion rights justices, if they were asked to explain their votes in McCullen.
Now we're joined by Professor Cindy Lebow.
Thank you, Adam. And welcome, and thank all of you for coming to this fantastic program. First, I want to thank and congratulate each of our panelists on their extraordinary presentations. So thank you so much. Last year, I had the honor of dedicating this program in the memory of my late husband, Allan Lebow. As you can read at the back of the printed brochure, and as many of my friends who are with us this evening know, he was an exceptional graduate of this law school who in his all too short career represented the very best that a lawyer can be. My pride in dedicating what was a modest memorial fund that had accumulated through the years to support the Whither the Court program cannot be adequately expressed. It has illuminated all that I have done this year, even as I myself, as Adam just suggested, became an adjunct member of this most distinguished law school faculty. I can't help but think that Allan would approve. As great as past Whither the Court programs have been, it was my hope that we would be able to combine the expertise of our own amazing in-house constitutional law scholars with new voices from outside the law school, underscoring the significance of this signature UCLA program. For a school located on the West Coast, I believe it is critically important to expose our students and our campus to different points of view, offered by scholars and experts of every persuasion who are more often seen and heard in Boston or New York or Washington, D.C., or for that matter, only on C-SPAN for some of us. In other words, I wanted to think big with the new funding that was available to support the program. However, tonight's keynote speaker exceeds even my expectations of big. Professor Laurence Tribe is the Carl M. Loeb University Professor and Professor of Constitutional Law at the Harvard Law School, having taught there since 1968. The title University Professor is Harvard's highest academic honor awarded to just a handful of professors at any given time, and to fewer than 75 professors in all of Harvard University's illustrious history. Professor Tribe entered Harvard in 1958 at age 16. He graduated summa cum laude in mathematics and magna cum laude in law. He clerked for the California and United States Supreme Courts. He received tenure at the age of 30. He was elected to the American Academy of Arts and Sciences at 38, and most recently he was elected to the American Philosophical Society. He helped write the constitutions of South Africa and the Czech Republic and the Marshall Islands, and he has received no less than 11 honorary degrees. He is also one of the nation's most respected and successful Supreme Court advocates, prevailing in 3/5 of the many appellate cases he has argued, and argued many more, including 35 before the United States Supreme Court. He was appointed in 2010 by President Obama and Attorney General Eric Holder to serve as the first senior counselor for access to justice. He has written 115, just think about that, 115 books and articles, including his treatise American Constitutional Law, which is cited more than any other legal text, and his most recent book, Uncertain Justice, The Roberts Court and the Constitution. He has achieved national preeminence, both as a scholar and as a practitioner of constitutional law. At the time we began planning this program, I was in the middle of reading Professor Tribe's newest book. I also teach the constitutional law classes, many of them in the political science department, and for me, Professor Tribe's new book was must-read summer reading. I was struck by the fact that every few paragraphs there would be some incredibly insightful comment about the Roberts Court or some member of the court or one Supreme Court decision or another, the kind of insight that could only come from Professor Tribe. When asked who we should invite as the first speaker to inaugurate our newly energized Whither the Court program, I couldn't help but think of how Professor Tribe's book could just as well have been entitled Whither the Roberts Court. Not quite believing that he would actually accept, I nonetheless suggested that we extend the invitation. But here we are, and I can only say how honored I am and how honored the UCLA School of Law is and the entire UCLA community to have you here with us this evening. In the interest of full disclosure, I had the opportunity to work with Professor Tribe back in the late 1980s when he consulted with the Senate Judiciary Committee, of which I was a senior staff member, on a succession of Supreme Court nominations. I got to see firsthand his towering intellect and encyclopedic knowledge of constitutional law, and the power of that experience has stayed with me ever since. So today, when some cocky undergraduate raises his or her hand from the back of one of my political science con law classes to ask some off-the-wall question that I have no idea what the answer is, I just say, you know what? The only person who could possibly answer that question is Harvard Law Professor Larry Tribe. But I never imagined, Professor, that I would be so privileged as to be able to introduce you to all of us this evening. Thank you so much for coming all the way to Los Angeles and for honoring this inaugural program with your participation. Without further ado, Professor Laurence Tribe.
Well, that's embarrassing. I'm sure that my mother would have loved it and my father might have believed it. I want to thank Cindy Lebow. It's an honor to be here, to be honoring all of you and her husband. I want to thank UCLA and the Williams Institute. It's really a great pleasure for me to be here. But without further ado, I want to get to the substance of what you have heard and of how I would like to tie it together. And I want to focus on a theme that lies beneath and connects a lot of what you've heard this evening. I mean, you've heard about 5 different cases, one of them about the Fourth Amendment, the others about either free speech or the Establishment Clause. It may seem like a strange potpourri. I mean, you've got very distinguished people up here, and these are the cases they wanted to talk about. But actually, there are deeper connections, and I want to try to pull some of them together. And to do that, I want to turn, briefly, I want to turn the clock back to my clerkship with Justice Tobriner here in California in the late 60s, just a couple of years after Jerry Brown clerked for the justice. That was when I had become a huge fan of Justice Brandeis's 1928 right of privacy dissent in Olmstead, which I assumed would one day become law, as the greatest dissents have a way of doing. It was the dissent in which Brandeis described privacy as a connected whole. He refused to accept the idea that government snooping on personal conduct and private conversations could not constitute a search without a physical trespass. And when the opportunity to overrule Olmstead arose during my clerkship the next year for Justice Stewart, I couldn't resist urging the justice to pounce. The issue reached the court on review of a criminal conviction based on the FBI's electronic eavesdropping from outside a phone booth. Remember those? A booth that a guy named Charlie Katz had regularly used to place interstate gambling bets. But to hold that the FBI had searched Katz and seized his words without a warrant, the court would have to overrule Olmstead because the eavesdropping device had not intruded physically into the booth or any other constitutionally protected area. Well, with Justice Marshall recusing himself, because as Solicitor General he had been involved below, the justices were deadlocked 4-4 at their Friday conference. And Justice Stewart, who wasn't sure whether even he was ready to overrule Olmstead, seemed reconciled to having the court affirm Katz's conviction the following Monday by an equally divided vote, setting no precedent. Well, I couldn't reconcile myself to that. I had just barely gotten to the court, but I was filled with excitement about possibilities, and I made such a nuisance of myself that the justice nearly fired me. I told him I would leave quietly if I didn't succeed in coming up with a draft over the weekend that could command a majority. I think just to humor me, he said, okay, give it a try. And the draft that I did that weekend, with only a few minor edits, ended up as Justice Stewart's opinion for a 7-1 court in Katz versus United States, overruling Olmstead. Now, the biggest intellectual challenge, and it was a big one, I didn't solve it, was how to get around the potential circularity of the now familiar test that I proposed, which focused on justifiable expectations of privacy rather than on physical trespass into a constitutionally protected area. I mean, how do you tell what's a justified expectation of privacy? Well, my suggestion was to marry the Fourth Amendment to the First in a sentence that said, reading the Constitution more narrowly would ignore the vital role that the public telephone has come to play in private communications. To me, Katz should long ago have been recognized as standing for the basic proposition that the First and Fourth Amendments are not simply separate stars in the constitutional constellation. They complement one another to create a firm anchor for a fundamental right of informational privacy, even if people are gradually conditioned socially or by government to expect that their privacy will be compromised because they've shared information with a third party or for some other reason. But as recently as 2011, informational privacy remained a right whose very existence the court was still merely assuming over the vigorous objections of Justices Scalia and Thomas, who said there's no such thing in the Constitution. In a case called NASA v. Nelson, Justice Alito wrote an opinion for the court holding that the space agency had not violated the informational privacy right, which he assumed arguendo existed when it probed not just outer space, but the inner lives of its would-be employees. Scalia argued that it was about time the court admitted that the Constitution protects no such right, but Alito wasn't about to admit it. The next year, when Justice Scalia wrote for the 5-justice majority in Jones versus United States that the FBI had searched the defendant by attaching a GPS device to the bottom of his Jeep to follow him around for weeks, Alito concurred separately on behalf of 4 justices to argue that it couldn't matter less whether the GPS was physically attached to the vehicle or followed it from somewhere in the cloud. Those 4 justices objected to Scalia's reliance on the past to save privacy's future. They viewed Scalia's originalism as quaint and blind to modern realities. Scalia, for his part, got a 5-justice majority only by treating Katz as irrelevant, because here there had indeed been a physical trespass of the Jeep. Now, the issue in that GPS case was how to decide whether a search had occurred. The issue in the cell phone case, discussed by Professor Carbado, Riley v. California, was how to decide whether an undoubted search was unreasonable. But the underlying problem was very similar, namely, how to keep the overlapping values underlying the First and Fourth Amendments from being overtaken by technological change or government practice. Sure, following a car by GPS for a month was, to use an analogy that Scalia found helpful, sort of like hiding a constable in a coach to follow its movement for weeks. But, as Alito retorted, that would have required either a gigantic coach, a very tiny constable, or both, not to mention a constable with incredible fortitude and patience. He was a little bit too classy to say, and with one hell of a bladder. In Riley, both California and the federal government argued that searching someone's cell phone upon arrest is indistinguishable from searching an arrestee's wallet and pockets for letters and other information. You could have your whole life in there, theoretically. But as the Chief Justice put it, that is like saying a ride on horseback is indistinguishable from a flight to the moon. The court's unanimous holding that cell phones are not within the per se-ish rule that Professor Carbado described and are not ordinarily subject to search incident to arrest was, I think, a welcome sign that the Roberts Court has finally arrived in the digital age. And when Roberts, a master of understatement, noted the absence of more precise guidance from the founding era, none of the court's originalists made a peep. It's true that the court in Riley did not explicitly invoke the First Amendment, but it made a big nod in that direction when it said that modern cell phones, quote, could just as easily be called cameras, video players, Rolodexes, calendars, tape recorders, libraries, diaries, albums, televisions, maps, or newspapers. A research assistant of mine back in the day, and a former professor here, now a law professor at Stanford, Dave Sklansky, has written a couple of intriguing articles suggesting a totally different connection between cats and the First Amendment, one focused on closeted gay sex. Professor Sklansky's thesis was that the court was influenced in cats by the pervasive use of surveillance into public restrooms by cops determined to catch gay men engaged in sexual acts. I've never been sure whether Sklansky was onto something, but I can tell you that the big sex thing, while I was clerking at the court, had to do with what the justices were doing in the basement. Now, wait, don't get me wrong. I'm just talking about what they did on Porn Day, which came around once each year. That's when they would solemnly watch porn together so they could define obscenity for First Amendment purposes. They created constitutional law one sex scene at a time. Justice Marshall took merciless pleasure in narrating the clips for the special benefit of Justice John Marshall Harlan II, an elegant former Wall Street lawyer who was by then losing his eyesight, mocking Justice Stewart's insistence that I know it when I see it. Clerks would call out in the dark, "I see it, I see it." Now, that was a funny scene, but I have been hoping for a while that the thought police would get shut down ever since 1969, when the court, in a case called Stanley versus Georgia, explicitly drew on both the First Amendment and the Fourth to hold that the Constitution forbids making mere private possession and enjoyment of obscene material a crime. The court in Stanley cited Brandeis's Olmsted dissent and wrote, "Our whole constitutional heritage rebels at the thought of giving government the power to control men's minds." And I would add, rebels at the thought of giving government the power to figure out who does or doesn't need somebody's advice. But I'll get to that when I get to McCullen. To me, the logic of the Constitution points to limiting government's role with respect to porn, to that of protecting kids, and keeping neighborhoods safe through rules about where explicit sex can be marketed, rules that I have long called erogenous zoning. The court hasn't quite taken that direction, although it has tried to paint with a more doctrinal brush. It's laid down what it sees as readily applicable bright-line rules that protect even the most extreme speech, like marketing to kids without parental permission, violent interactive video games, which are deemed protected as long as they don't meet the court's latest definition of obscenity. You can protect kids from sex, but not from interactive violence. It's a bizarre concept. Or gay-bashing protests at a fallen soldier's funeral, invading the privacy of his family. Those are instances of speech that I wouldn't have minded seeing the court treat less tolerantly. Decisions like that have given the Roberts Court a reputation as aggressively pro-First Amendment. It's a reputation this court has not always earned. I'm thinking of the cases in which it has upheld censorship of students, whistleblowers, human rights activists, or mind control of prisoners, punishing them by taking away access to television, radio, newspapers, any reading material. I anticipated that Sue Dunlap, whom I admire greatly and with whom I share profoundly the cause of protecting women's reproductive rights, I anticipated that she might argue that the Roberts Court should have permitted Massachusetts to, as I will put it, censor sidewalk counselors like Eleanor McCullen and McCullen v. Coakley, and Sue didn't disappoint me. She pointed out, I think quite rightly, that most women certainly don't need one more person trying to talk to them. They're already making an incredibly difficult choice, but my question would be, do we need Massachusetts deciding what women do or do not need? I agreed with the bottom line at which all 9 justices, including, as Eugene Volokh points out, Sotomayor, Kagan, Breyer, justices whom you would ordinarily, given their commitment to reproductive freedom, think would be sensitive to these issues. I agreed with the bottom line at which they all arrived in that case. Massachusetts had gone too far with its 35-foot buffer zone because it required even peaceful, non-harassing folks, they may be naive, they may not be needed, but they're doing their thing, and that's what free speech is about. Requiring even them to stand so far back that they had to choose between yelling at the women that the state claimed to be protecting and saying nothing at all. And as I'll explain in a couple of minutes, I think a major theme of the Roberts Court is to invalidate certain forbidden choices. That's the hallmark move that this court is making, certain choices that the government is forbidden to present to people, offers they would rather not receive. More narrowly targeted protection, prohibiting counselors from harassing women as they approach any healthcare facility, from holding up pictures of dead fetuses in their face, requires more police effort, costs taxpayers more than a simple 35-foot buffer zone. But I think Roberts was right that free speech trumps convenience and efficiency. Massachusetts has now written a new law that I helped the Attorney General's office draft that is going to cost the state more, but it's going to protect women from being followed. It's going to give them the right to say, leave me alone. And once they say it, the person who continues to pursue that woman will be committing a crime. It is too bad the court doesn't see the same thing when it comes to the 250-foot buffer zone around its own building. The court, being judge in its own case, obviously is a little two-faced on some of these issues. But what Roberts did was subject the state's restriction on speech to skeptical scrutiny. He was unwilling to accept the claim of Massachusetts just on its say-so that none of these less restrictive alternatives would work. And I think that's the right thing to do, just as all 9 justices in Riley responded to the administration's claims and the claims of the government of California that it really needed to be able to search these cell phones by saying, prove it. We're not convinced. We're not willing to simply take your word for it. I do think that Roberts was wrong in his debate with the 4 justices who said that this was indeed censorship because the law was content-based and maybe even viewpoint-based. I think the majority's attempt to deny that and to say, no, it's sort of neutral but just goes too far, was probably, its attempt to deny that was probably unconvincing. Where I think the other 4 justices erred was in complaining that the majority was approaching abortion in a special way. Scalia claimed that the majority was reading from an entirely separate, abridged edition of the First Amendment, applicable only to speech against abortion. He's got this, bee in his bonnet or whatever you want to call it, that basically tells him, my colleagues are much too tolerant of reproductive rights. Well, I think he's wrong there. I think the majority did implicitly take into account that there were rights linking personal privacy to freedom of personal expression on both sides of this case. The right to have a private conversation, naive though it may be, as the only place where someone like Eleanor McCullen could reach the women that she thought she might persuade, but also the right on the part of the woman to carry through with a profoundly sensitive private choice without being talked to by a stranger. And it seems to me that it's hard to balance those rights, but the court didn't do too bad a job. There is one argument against the court's buffer zone decision that I find especially puzzling, and that is that the quiet private conversation that Eleanor McCullen was naive enough to try conducting from closer than shouting distance wasn't part of any genuinely public political dialogue and therefore was not protected at all by the First Amendment. No less an authority than Judge Richard Posner, who, by the way, today wrote a brilliant opinion on the issue of same-sex marriage, giving great ammunition, I think, to Kennedy and making life harder for Scalia. No less an authority than Posner has endorsed that view, but I think it's deeply wrong-headed, just as it was when Robert Bork, against whom I testified, I think, when I was working with Joe Biden and Cindy, advanced a virtually identical argument about non-political speech years ago. The First Amendment is not a protection only for robust, no-holds-barred public debate between sort of competing groups on explosive topics like abortion and race relations. It's not only that which the First Amendment protects from government interference, it's also quiet, individual, face-to-face private conversation, however foolish and unneeded some of us may think it is. A view that links the First and Fourth Amendments would see that immediately. Informational privacy is about controlling with whom you want to communicate what, and not giving the government the power to make that decision. That's why I disagree with people like Yale's law school dean, Robert Post, and actually circuit court judges, some of them in both the Ninth Circuit here and in the 11th Circuit, who have argued that a doctor's private advice to her patients about gun safety or about sexual orientation gets no protection from the First Amendment because it's not part of public civic discourse. I think that's a dangerous path down which to go. Broadly speaking, I think both the First and Fourth Amendments should be understood as safeguards against centralized government determination of who should be allowed to say what to whom, with whom we may share what we say, and from whom we should be permitted to hear what. And that's why I'm also unconvinced by Robert Post's argument that Citizens United was totally wrong for the reason that all this money spent by wealthy guys like Sheldon Adelson or by corporations is not really part of useful public discourse, and that the government can restrict it as long as it does so for egalitarian, pro-democratic reasons. I share the sense of both Post and of my colleague Larry Lessig that the court went wildly wrong by understating the magnitude of the problems caused by unrestricted campaign spending, that it went wrong by defining corruption so narrowly that it includes only quid pro quo bribery. That's already a crime. That it was wrong in downplaying the problem of undue dependence of office holders on big spenders. But I think despite all of that, it was right to apply the strictest scrutiny to the regulations Congress had enacted, and probably right to strike them down. You know, I don't see any way to distinguish an anti-Hillary Clinton movie produced by a right-leaning corporation like Citizens United from an anti-Mitt Romney or an anti-Jeb Bush book produced by a left-leaning corporation like a hypothetical Citizens Divided. And the last people I would trust to decide who should be permitted to spend how much to support or oppose various political causes are the very office holders whom we suspect of being bought and paid for. Now, in McCutcheon particularly, I think both defenders and critics miss the boat when they focus on whether the decision is a defensible stepping stone to repudiating the Buckley distinction between spending and contributions, or even when they focus, as some political scientists do, on whether it's better or worse, to have more of the money flow directly to candidates and their committees, more transparently, or darkly to more directly to candidates and their committees, or darkly to super PACs and 501c4s and 527s. To me, the strongest defense of McCutcheon's holding, the holding that Congress violated the First Amendment when it limited aggregate contributions, is that such a limit made citizens choose between spreading their contributions around to a lot of different causes versus giving larger sums, still within the legal limit, but larger, to each of a smaller number of causes. The Chief Justice specifically recognized that imposing that choice between broad and deep contributions was just as burdensome as a law saying you can give, but only to 10 causes, or only to 20 causes. McCutcheon is actually closely aligned with other Roberts Court's decisions that haven't gotten much press because they were so nearly unanimous and they were harder to dramatize as following the ideological split. Decisions like last year's Agency for International Development versus Alliance for Open Society, the AID case. There, over the dissents of Scalia and Thomas, wrote a landmark First Amendment opinion that struck down an act of Congress because of the demand that that act made that organizations which get discretionary federal funds to assist in their global fight against HIV/AIDS join the government's pledge against prostitution. Congress said, if you accept our money, you've got to take our anti-prostitution pledge, even though you believe that taking that pledge would alienate the sex workers whose cooperation you need if you are going to succeed globally in combating HIV/AIDS. The Roberts Court held that imposing such a catch-22 violates the First Amendment. Now, the decision hardly made anybody's radar screen. It wasn't even on the agenda for this evening. But it fits into an important pattern of cases in which the Roberts Court, contrary to the impression that it doesn't do anything very exciting in the progressive direction, has begun to take a really hard look at government offers to give individuals, and sometimes states when we're talking about the federal government, things the government is constitutionally free to withhold when the offers are conditioned on sacrifice of a federal constitutional right. That's what I think is wrong with Grease v. Galloway. I think it represents a failure on the part of the Roberts Court to show the same sensitivity to that kind of catch-22 that it showed in McCutcheon and in AID. When Kennedy wrote the opinion that Eugene Volokh has well described, upholding a town's practice of opening its monthly meetings with a prayer by an invited minister, almost always Christian, he was, I think, right to focus, as he had in Citizens United, and this is a theme that I don't think Eugene underscored, on the dangers of government censorship. Censorship of religious speech to make sure that prayers are well-balanced and not too sectarian is every bit as dangerous as censorship of political speech to make sure that the playing field is properly balanced. But what about the rights of citizens who want to take part in public self-government, especially when that's the only place they can go to get the zoning variance or some other benefit that they want, but feel privately uncomfortable about sitting through any prayer every time they do so, and would feel even more uncomfortable being outed as nonconformists if they left the meeting while the prayer was being offered. Kennedy made a big deal of the fact that this is not coerced, they're not forced, they can love it or leave it. Well, that's also true of the groups seeking discretionary government money to fight HIV/AIDS. They didn't have to accept the money. Scalia and Thomas said they can just say no. Roberts said that's not enough of an answer. Love it or leave it, you could just say no is not enough of an answer. I think Justice Kagan's otherwise marvelous dissent, and I'm a little biased because she was a research assistant of mine on the second edition of my treatise, but then I also taught Roberts, so the bias is pretty well spread. I think her dissent didn't go far enough when she conceded, as Eugene rightly stressed, they all conceded that it's fine to have opening prayers as long as they're bland and generic enough and sufficiently broadly representative to satisfy everybody, except, by the way, the totally secular ones, the atheists, the agnostics. They shouldn't have made that concession. The Obama administration was at fault, I think, when it submitted a brief saying you should all start from the assumption that legislative prayers, which we've had throughout our history, are fine as long as the prayers are sort of the right ones. Well, that's ridiculous. Maybe it's okay to have Congress start with a prayer, for the Supreme Court to say at the beginning of every session, God save this honorable court and the United States. We could use all the help we can get. That's all that statement means. But when a specific prayer is made, how do you think people would feel if when you go up to argue in the Supreme Court said, and now, while you are standing at the podium, listen to this prayer, as long as it's properly selected. I mean, that would be horrible. It's totally different when the prayer faces outward than when the prayer faces those who are making the laws themselves. Well, tonight I've praised the Roberts Court trend of closely scrutinizing the burdens imposed by government choices on those who would rather spend their contributions broadly rather than deeply, and those who want to fight a disease without having to choose between turning down government assistance and taking a public pledge. I see this time. Are you giving me 20 minutes? I mean, I just have another minute, okay? I won't keep you long. I think the insensitivity of the court in a case like Town of Greece was marked especially by the fact that participating in self-government is no mere discretionary benefit like getting federal bucks. What it is a right. It's the right of petitioning the government for redress of grievances. It's a First Amendment right. So you've got a court that is quite differentially sensitive to these burdens, especially if you look at an argument of the sort that I think Doug was right to make with respect to the difficulty of the kind of accommodation that the court required in Hobby Lobby when you take into account complicity-based third-party harms. You end up with a court that, on the one hand, is being extraordinarily innovative in some of its sensitivity to choices that people should not have to confront from the government. On the other hand, it is being differentially sensitive, more sensitive to the burdens on a Christian family-owned company than on the Muslims, Jews, atheists, agnostics, and pure secularists who are made to feel uncomfortable in the town of Greece. And when you see that kind of inconsistency, the temptation is to say, oh, it's just politics. It's just identity politics. It's a matter of their personal beliefs. Well, I can tell you that if there's one thing I've learned from decades of teaching this stuff and writing about it and arguing in the court is that it's usually a lot more complicated than that. Of course, the judges are human beings. Why would we need 9 of them if it could be done more mechanically? If Roberts had been right, that it's just like an umpire calling balls and strikes. But then one famous umpire once said, you know, the strike zone is a living, breathing document. Well, I think it's more complicated than that, and I've tried in my book to make that clear, and I think this evening has been a very interesting discussion, and I hope that we can continue it with all of you. Thanks a lot.
Well, thanks to all our panelists for great presentations. We do still have a few minutes, about 10 minutes or 15 minutes, for questions. If there are questions from the audience, we'd be happy to take them.
Michael Smith, who I notice is the leading tweeter on the UCLA SCOTUS Review Twitter feed, so I appreciate your live coverage.
Well, thank you very much, all of you, for your commentary and your summaries and analysis of the case. It's been fascinating to hear. Thank you especially to Professor Tribe for making your way all the way out here to the West Coast and giving us such an excellent speech and excellent analysis. My specific question, though, is, if you're following me on Twitter, has already been spoiled, but is for you, Professor Tribe. You mentioned in discussing the First Amendment as well, you said that it was deeply wrong for the court to have concluded that sidewalk conversations, private one-on-one conversations, are not protected, or in the very least less protected under the First Amendment. You then mentioned the example of 9th and 11th cases dealing with doctors and giving their speaking to patients about gun safety, recent decisions saying that those restrictions on doctors being able to talk about gun safety are fine. My question was, how would you react to a case then like Pickup versus Brown in the Ninth Circuit, where California restricts speech by doctors to patients in situations involving sexual orientation conversion therapy? California outlawed it, the Ninth Circuit said that was fine, and my understanding, it's been a while since I read it over, was that the doctor's speech, or at least the context of the doctor's office, was a less protected environment.
Yeah, that decision, the Pickup decision, struck me as very difficult to sort of think hard enough about, to really think clearly enough about. On the one hand, I think the conversion therapy stuff, is completely bogus and harmful and hurts the dignity not only of the people who are subjected to it, but of others who, as observers, can see that the very existence of this kind of stuff is a way of denigrating their lives as though they were a disease. That's horrible. It seems to me that might provide a sufficiently compelling interest for the government in its role of regulating the profession to say that, there are some things you can't do. You can't tell your cancer patients that if they stand on their head, they'll be cured, that's fraud, and that's not permissible. I think astrology may also be fraud. But it seems to me that for the government to say, we are going to outlaw astrology because there's no, it's a bunch of bogus stuff, or we're going to outlaw the teaching of creation science because it's not a science, would go too far. That is, I think there's a big difference between a court like the Ninth Circuit in Pickup or the 11th Circuit in that unpronounceable case, I forget the multisyllabic name, I think there's a big difference between saying that the First Amendment doesn't enter the picture, because after all, this is advice by a doctor to a patient, and saying that although the First Amendment protects this discourse, there are, of course, countervailing interests. Speech is not absolutely protected, and the old routine of shouting fire in a crowded theater when there is no fire. It seems to me that telling people that if they set their hair on fire, they're going to straighten out their lives would be something that the government could prevent when the people are gullible enough perhaps to believe it, or when their kids and their parents put them through that kind of therapy. But in general, I think it's dangerous to carve out from the First Amendment these black holes of exception where we don't even have to think about whether the state's interest could be met in some narrower way or whether it has a compelling interest. And I think in general, suppose you're not a licensed lawyer, but you tell somebody, I think that it would, you really ought to sue the bastard. It would be a good idea. And I think the government, to have a kind of patrol going around and saying that there's a kind of legal element in your advice, and because you didn't graduate from UCLA and take the California bar, we're going to let the occupation sort of push the legislature to making that a crime without any First Amendment analysis would be wrong.
Thank you. This question is for Professor Volokh. Earlier we heard in the Hobby Lobby case, it was characterized as allowing family-owned businesses to condemn sinful activities in their eyes. I wanted you to respond to that, whether you think that's an accurate characterization of the case.
Well, First Amendment protects the right to condemn sinful activities. The question is, to what extent did the Religious Freedom Restoration Act federal statute that Congress passed nearly unanimously back in 1993, gives, in this case, small, closely held for-profit corporations the right to refuse to participate in certain behavior that they think is improper when, at least according to the court, and this seems probably likely, that refusal doesn't really tangibly hurt third parties because there are other means for the government to accomplish their goals. And I think under the Federal Religious Freedom Restoration Act, that's probably the rule. The whole point of the statute was to provide religious objectors exemptions, not from things that we think are wrong. By definition, if we thought they were wrong, we wouldn't have enacted the statute, at least our representatives wouldn't have, but things that they think are wrong, if in doing so, they don't jeopardize compelling government interests because the government can step in and serve those interests some other way. Given that that's so, assuming that the court is right, that the government can provide the same kind of free access to contraceptive care for women employees through means other than this employer mandate, then in that case they ought to have that entitlement. Now there are two possible objections. One is they're a corporation and not individuals. I think that's a mistake. I think it's a mistake to just assume corporations just automatically have all the rights that humans have. I think corporations are fictions, but at the same time, it's also a mistake to assume that you can burden corporations without burdening people. When you impose this kind of obligation on a corporation, you're imposing it on its owners. Imagine there was a law that said all corporations that own service stations have to sell lottery tickets. And somebody, a Muslim or I think a Mormon or maybe Methodist, some other groups object to participating in gambling. And they said, look, you know, I own this business with my brother as a closely held corporation. We don't want to sell tickets. And the government says, oh, no, you're just a corporation. I think that would be a mistake. That would be hiding the reality of the real human beings behind the corporation. So I think that's why the majority was right in saying that corporations can make this claim, at least closely held ones. And incidentally, 2 of the 4 dissenters actually didn't even opine on that. So it was a 5-2 decision on those lines. And then the next question is there something too attenuated about the complicity involved there? And I think that the Supreme Court quite correctly held back in the Thomas case back in 1981 that when you're dealing with religious exemptions, you don't impose our own notions of what constitutes proximate cause or what constitutes aiding and abetting, notions that, by the way, are widely variable from jurisdiction to jurisdiction and area of law to area of law. But you ask whether this is sinful in this person sincerely believed to be sinful by the person in his scheme of things. And if the answer is yes, then in that case you get an exemption. So I think as a statutory matter, I think the court's decision was quite right. Now, if it weren't for RFRA, I don't think that the objectors should have a free exercise clause exemption as a constitutional entitlement. I think the court was right, Justice Scalia was right in Employment Division versus Smith in saying there's no constitutional entitlement to religious exemptions. But Congress said is we want to create a statutory entitlement back in 1993 to such exemptions, and that's what the court implemented here, just as it implemented with regard to drug law back in 2006 in the O Centro case.
But could I just ask, what about Professor NeJaime's idea about dignitary harm? I mean, suppose the court seems to say that an anti-discrimination law would be different because, unlike contraceptions, which could be provided free by the government without any of the complicity-based sinfulness concern, there's no substitute. Well, sure there is. If McDonald's suddenly says we don't want to hire gays or we don't want to hire lesbians or something, the government could hire them. It could hire them and pay them more than the pittance that McDonald's pays, but there would be the dignitary harm. They want not to be singled out and treated differently because of this characteristic of theirs or race. It seems to me that the court's attempt to avoid some of the most distressing implications of its decision is kind of incoherent.
Well, but the whole point of the Religious Freedom Restoration Act, just as the point of the Religious Exemption Project altogether, a project that was begun by Justice Brennan and was for a long time seen as a project of the left, is you don't just say, oh, look at this parade of horribles, the end result will be either anarchy or oppression of innocent third parties, therefore no religious exemptions. You decide on a case-by-case basis what is a compelling enough government interest and when is it sufficiently jeopardized. Again, I think as a constitutional matter, that's a mistake. That's why I was with Justice Scalia rather than Justice Brett and Employment Division versus Smith. But if Congress says, as many state legislatures have also said, that we want courts on a case-by-case basis to decide what's a compelling enough interest, it may make sense that they would say that in certain situations, dignitary interests are sufficiently compelling. But when the government doesn't even assert a dignitary interest, probably a wise move, because I don't think this is the sort of thing that I doubt that even the liberals in the court would have viewed that there's a compelling dignitary interest in making sure that the contraceptives are indeed provided, actually the alleged abortifacients are indeed provided by the employer and not by the accounting gimmick that the government set up, then if there is no such compelling interest there, then the exemption trumps, and it has to be done on a case-by-case basis, or that at any rate is the principle of the RFRA, like it or not.
We are unfortunately out of time. I apologize to those who had questions and who are waiting patiently. But thank you all for attending our Whither the Court this year, and a thanks especially to our panelists. Please join us outside for a reception and a book signing. Thank you all.
Yeah, exactly. That's right.